So there are really three phases and costs that every estate plan has to deal with. There's the cost to create your plan on the front end, or not pay any cost to do it. There's the cost to update your plan, and sometimes a bigger cost to not update your plan because, again, the less updating that is done, the more likely the plan will not work. And then there will be a cost in some manner to settle the estate assets that you have when you pass away. There's really, in the upfront world, there's really two ways to go about it. You can do the word processing method if you're going to do any planning, or you can do more of a counseling and design model where you have this more intensive give and take and questioning and back and forth.
And making sure we get stuff right.
Most importantly. Well, why is updating important? Well, there are a number of changes that impact on your plan. We've touched on some of these earlier, but we'll point them out in more detail now.
As if my babysitting story didn't fully explain why updating is important.
Clearly, right. Clearly, there are changes in your life cycle and phase. Your personal circumstances would change with, marriages with your kids, and changes in your business and your investments and grandkids and divorces, hopefully not, deaths, things of that nature. And your financial picture is going to change too. The laws are going to change. We know that. There's thousands and millions of laws out there. Tax laws are all changing. Depends on who's in office, what the world economy is like, and all that. And the other thing, the one that's probably least thought about, is changes in your attorney's experience. We've been doing this a while now, me a little more longer than Austin and a little longer than Megan, and we are constantly striving to improve and enhance our knowledge. We go to CLE programs, we do webinars, and what we don't want to have happen is where we learn something really great or the laws have changed that we need to incorporate in our planning, and we have no process to get our clients who we met with last month or last year or 5 years ago that new information. So as we'll talk about in a few minutes, we do have a process to make sure you and all our clients have a way to keep everything current. Yes?
Yeah, so it's kind of self-evident, but could you just elaborate a little more in the upfront phase, like what, and the counseling design, of course. What kinds of, aside from, I can imagine, the initial interview, does this take place in a couple of steps?
We actually have that all explained in a couple of minutes. No, you're good. That's actually a great question because we need to explain it, and we're going to.
So the reality is, as I think people in the room probably personally recognize, people on average wait at least about 20 years before ever revisiting their estate plan. And you can see the pitfalls and the problems that addresses. And also people have trust. Many people now do have more and more. When I started doing estate planning as the primary part of my practice in 1999, trusts were still fairly rare, especially in this area. Now a lot of attorneys and other non-attorneys, frankly, are doing trusts. But the reality is very often they are not fully funded. I'm dealing with a scenario where we had 3 children. Their parents did planning in Florida. I helped form an LLC for them. They own a commercial building in Rockland County. And I set up an LLC, and they had a revocable trust done in Florida. After they both passed away in their late 90s, I got the information. Their financial advisor basically handled everything. He just had an attorney on the side, I think, cranking out trusts for these people. Their trusts were fine, but the attorney had a letter specifically to his client saying, by the way, I'm not doing any funding for you. That's totally your responsibility. So you know what happened? Do you think they got funded? Mm-hmm. Absolutely not. Mm-hmm. So that's led to a lot of chaos now. All right. The settlement phase, some people say, like these people thought and their kids thought, they had this trust, so there's nothing had to be done when they died. Mm-hmm. Dad died a year and a half ago. Mom died this past May. They never administered the estate after Dad died, and they haven't done anything since Mom has died. They wanted to put the commercial property in their names. I said, hold on a second. You don't have authority to do that. In the trust instruments their parent created in 2008, it established generation skipping trusts for each child, which is a whole nother level of tax issue that we got to deal with. And I said, this has to be done according to the instrument. People get these things done all too often, and they never look at them again, and they totally ignore everything they did in the first place, and their kids certainly have no idea what happened. Mm-hmm. It becomes a complete, cloud story gone bad on steroids, and that's what the case we're dealing with now.
So should the beneficiaries be in on this to know what's going on?
It's a good question. Question, should the beneficiaries be in on? We certainly encourage the adult children, to the degree the parents are comfortable, to be participating in the planning or the conversation, or at least become up to date on what's going on even after we initially meet with the parent. We can have a follow-up with the kids or do a telephone call.
What we like to do, and we kind of get to this a little bit more, we do like to have sort of like a family team meeting, but it also depends on the client's comfort level. Some clients just like, look, my kids, they can worry about it when the time comes. I don't want them involved now. And that's fine. Again, we're here for you guys. It does sometimes help to have them involved. It depends.
Right, so these are not magic books. These trusts that we do, everyone gets a nice red book or multiple books depending on what their planning entails. They don't just do things when you die. They don't sprout an arm and a leg and head and run around. People have to be involved to make this happen. It's going to be professionals, it's going to be the family members, and the more coordination there is among everyone, the more likely the plan's going to work exactly as we want it to be.
How old is this legacy program of yours?
Since 1999 I started.
Oh.
Yeah, so this is not new. So the reality is 75% of American families, give or take, haven't done any planning. I think we got this from a Reader's Digest article years ago. I have to probably revisit, see what they have. More comprehensive statistics. But Reader's Digest is very reliable. For a lot of reasons, people just haven't done it. Some people, again, there's a fair amount of people don't have assets that really they would necessitate it. But even if you don't have assets, you should certainly have a healthcare proxy and living will. So people don't do it. Our process on the Legacy Assurance Program is really based on 3 fundamental components. First is to work with a counseling-oriented attorney. We pride ourselves on our counseling skills and our ability to really work with families to get the right result, not from what we would do if we were you, but from what you will do in educating the client about the possibilities. This workshop is the first step in that education, right? You guys come in to see us on an individual basis. If you do so, you're going to be much better ready to hit the ground running than if you just came into us cold. Maintaining a formal updating program. So we have a process where we currently have, I think, about 254 clients, either individuals or couples, who are part of this program, where every year they get notification of education meetings that we do throughout the year in this room, not quite 3 hours, usually about an hour, hour and 15 minutes. We talk about what's happened in the world of estate planning, how the laws have changed, things we've learned, what we're updating our documents, a general overview. And we also do a planning spotlight. One of the things we talked about, and I ran it by clients yesterday, they thought it was a great idea. For 2016, our advanced or planning spotlight topic is going to be what happens if I become disabled or die. Sort of revisiting some of the things we talked about, but people don't remember how the trusts are administered and stuff. A little refresher for people. That's all part of it. The updating program also incorporates getting updated documents on an as-needed basis. Every year we change some documents, some more years than others. So even if you tell us and we send you an update worksheet or planning review worksheet that shows you in a summary, like a 9 or 10-page summary, what your current documents today say, you may tell us, and we have check boxes, yes, make a change, no changes. Even if you say on that form, I have no personally driven changes that we want, we're still going to want you to come in because we're going to have changes that we want to build into your documents that are legal or structural or otherwise, so that your documents are as good today as the people we meet with for the first time. So even if you started with us in 2008, your documents have been updated every year. And we want to make sure that all our planning is done at controlled and fully disclosed cost to you and your family. We're going to go through that now. Now, traditional probate fees, New York follows what is known as the reasonable compensation statute. Reasonable compensation is pretty much whatever the lawyer and the client agree to make it reasonable. Some states have statutory requirements. Florida, Indiana say an attorney will get paid 1.5% of the estate value. New York doesn't do that. Most attorneys, many of them still do a flat percentage. Average tends to be about 3%. So for $1 million estate, it is not uncommon for an attorney to charge $30,000. Often they tie it to an executor's commission, which is roughly that amount of money. Under the Legacy Assurance Program model, our fee from soup to nuts, the initial planning, funding, maintenance, and settlement will not exceed between 1 and 1.5% of your total assets. And let's talk about how that looks. So the traditional model looks like this. We have our teeter-totter, we call it. The upfront phase, as we emphasized, and pretty clear, is the word processing kind of structure. The cost is pretty low, but the value is low to minimal. There's no funding done. People don't think, oh, okay, we did our basic wills. We've got to sit with a lawyer and talk about how to change our assets. No one does that. And there's no formal maintenance. Attorney gets the will, they put it in the fireproof safe that we all have or at the bank vault, and they sit there waiting till a person dies. And then, by the way, the kids come in, or the grieving widow, attorney says, yes, your husband has $1 million estate, your father has $1 million estate, my fee is 3% of the estate value. That's how it works. Oh, and if we have estate tax returns, which are less common than they used to be, most people farm those out. We do them in-house. And probably the biggest question, are the personal planning goals addressed? Inevitably, the answer is no. We look at all those cloud story questions, and they haven't been addressed. So our model takes a different approach. We take this teeter-totter and shift the value where more of it belongs on the front end. Our design and counseling approach works as follows. We're going to take, our fee is going to be based on 0.5% of the taxable estate. Going back to your question from earlier, we have a range, a $5,000 minimum and a $15,000 maximum for foundational planning. So if you come to us and say, I like what you said, but I really want to protect my assets against my own creditors, and I want you to set up one of those Delaware or Alaska trusts, that's not foundational planning, that's advanced planning. But all the other stuff we talked about, the Medicaid and the revocable stuff, that's all generally foundational planning. Now, many times we're just doing either a Medicaid trust for a couple, either joint or separate, or we're just doing revocable trusts. That's all part of the foundational approach. If we're doing a revocable trust and we're adding a Medicaid trust to it, that will be an extra $1,500. Because sometimes people will come in and and they have really good long-term care insurance, they don't need a Medicaid trust. So it's on a case-by-case kind of basis when we deal with that. If we are going to do a standalone retirement trust, we're talking $2,500. That's not per person with a couple. That's per couple as the total fee, or if an individual. So if you're single and you want to get more bang for your buck, get married, and we can get you less expensive planning that way. Of course, there will be other costs associated with that anyway. So the range runs from the 5 to 15, and these are just the only really add-on fees that may or may not apply. We do have a funding process. We don't give the client a letter and say, you got to fund this on your own, because that would be really a dereliction of what we need to do. We have a full-time funding coordinator. Her name is Francine Fry, and she does all the paperwork as we discuss. Austin and I or Megan will meet with you individually when we do the planning to figure out how the funding needs to be done. Francine handles the mechanics of it. And we do have a fairly modest funding fee of $65 per funding action. So for those who have 1 or 2 investment accounts and a deed, it's not very costly. People have 20 CDs with 20 banks, that's going to be more costly funding. This often encourages people to consolidate their assets to save on funding costs, which is perfectly fine.
It tends to be a good idea anyway.
Yeah, an average funding cost, I would say, runs between $400 to $600 total. Now, the maintenance fee. We have been, when I started, the first year of maintenance was in the year 2000. All right, that was our first update year. We charged $300 for the maintenance cost for that year. I've been at $400 for a few years, and I've ran the CPI index. We're going to keep it at $400 in 2016. So the increase has been extremely low, and we're just targeting inflation, which has been low, so we haven't had to raise it that much. For the update maintenance fee, you get the things we talked about, the education program, updated documents. We review your funding every year to make sure that what you have still makes sense. And one of the biggest benefits of it is that it entitles you to have unlimited access to any of us for phone calls or emails regarding any estate planning or elder law questions you have without extra charge, which really facilitates the communication amongst all of us, Because clients, inevitably, if we're doing hourly billing, which we do relatively rare of in our practice, if you're doing litigation, you're always getting hourly bills. The last thing you want to do is call me with a question and get a bill in the mail for a charge. That's not going to really encourage you to call us with a question. So by having a flat maintenance fee for that, it really solves a lot of those issues. And then at the end of the day, we know because we've done really good planning up here, we funded and maintained it, we can greatly reduce the cost of the settlement upon death. We agree in advance as part of our fee agreement with the client to a cap not to exceed 1% of the estate value to settle your estate. And the cap is important because that is the top end. We are, especially in cases where we don't have to file estate tax returns, which are fewer and fewer that we have to, the costs go down significantly because the settlement is much easier. If we have all the assets, I can settle an estate in a couple weeks. It could be a $3 million estate. I can knock it out in a few weeks. Costs will be minimal for doing that.
The better planning we do on the front end, the less stuff we have to do on the back end.
Right. It's quicker for your heirs to get their assets in the right way. And so most importantly, cost aside, the personal planning goals are all satisfied. So we think this is a much more applicable, user-friendly, and comprehensive approach that really works for the client and gives us appropriate compensation for our knowledge and our participation. Yes?
The way in your investment accounts, your, for example, IRA annual fee can come out of the account?
Yeah.
Can your estate fund the maintenance fee?
Of course. Oh wait, the maintenance fee?
Yeah. Do you have that?
What do you mean your
the
estate?
Maintenance fee. Can whatever you put together here, can those monies?
Well, we don't invest your money. We don't do any of that.
Right. No, not invest.
You can tell your broker, send them a check for $400, I guess, if that's what you're getting at.
Yeah.
Have it on auto pay, yeah. So we send the bill out in January, and then it can be done that way.
You mean like your trust assets?
Yeah. Right.
Well, you're in control of your trust assets.
Yeah, we don't have anything to do with that.
If you want to pay us out of your trust assets, then yeah, absolutely.
Yeah, we don't administer it like, the broker, the financial advisors, or will take it out of they'll take their own commission. We can't do that.
Right. We're not holding your money here.
That's
We just
right.
take legal documents
Yeah.
and you're in control.
But you answered the question.
Right,
Right.
good, okay.
There are a couple cases, and I won't dwell on them just because of the interest of time tonight, that really show the uncertainty of attorney fees in these uncontrolled estate scenarios. Here's a case from about coming up on 5 years ago. There was a big fight amongst the heirs, and the attorneys, everyone had their own attorney. Ultimately, the court approved on a $1.75 million state attorney fees of $300,000. This was in New York City, New York County, which was 17% of the total estate value. What's even more interesting is that, well, the court noted that the typical fee in an estate of modest size was between 5% and the single executor's commission. So roughly between 5% and 3.5%. Here the attorneys filed a petition subject to court approval asking for fees of just under $814,000, which would have been 46% of the estate. So the court knocked them down to only $300,000. I would take that fee.
Every day.
Every day.
Right. Clients wouldn't like it, but
Here is even a lower estate value case, but a much worse set of facts. State of Smith from Bronx, about 4 years ago now. Here's a case. A guy died in 2006, November of 2006. The only asset in that estate was a piece of real estate for about $366,000. The attorney handling the estate, who also done the will, had a retainer agreement with the executor, said that his fee would be equivalent to the executor's commission, which is estimated to be at least $16,000 for one single asset. The agreement added that in the event that the probate proceeding became contested, then he would receive an additional fee of $400 per hour. As I said, the attorney handling the estate was the draftsman of the will. His former secretary was one of the witnesses. Now, here the attorney failed to prepare a routine document called an affidavit of witnesses that is typically signed at the time the will is signed by the two witnesses, so that if one of them drops dead or they both drop dead, they don't have to appear in court. They just submit the affidavit that is self-proving that they witnessed the signature and that they believed that the testator was competent. So here the attorney did not do the affidavit of witnesses, and when the will was submitted for probate, he could not get his former secretary to sign the affidavit of witnesses. We could only assume they probably had a bad breakup in their relationship, business relationship, and so he or she wouldn't cooperate, whoever the secretary was. So it wasn't until 2.5 years later that the attorney told his client, the executor, oh, by the way, one of your siblings is now contesting it, so now I'm getting an hourly billing for all this. Finally, 2 years after that, the executor fired the attorney, we can only assume for incompetent handling of the estate. Mm-hmm. On his way out the door, the attorney said, oh, Judge, by the way, I'm owed $29,200 for all my excellent work in this case.
The attorney that screwed it up to begin with.
Yeah. The court, against which I think was even ridiculous, allowed him to keep his original retainer of $16,000, which was still 4.5% of the total estate value. But look at the kicker here. As of the court's decision of December 19, 2012, the will had still not been admitted to probate because it didn't meet the statutory criteria of the 2 witnesses, and the parcel of land remained unsold. So think about, what was the real estate market in 2012 compared to 2006? Better or worse? Worse. Mm-hmm. So the property had declined in value. They're still paying property taxes for all this period of time. And the guy walked off with a $16,000 fee. Yeah. He's the only one who won.
Thanks for screwing it up.
Yeah.
I'm sorry, wait, 60, you said the court allowed him to keep?
16,000.
Right, right, 16,000 fee, right? Plus, wouldn't the heirs need additional attorney fees to help settle this?
Oh, I'm sure someone else is going to get a fee when they get through
that. There's more money getting paid.
There's more money getting out of this thing. Yeah. So that's so Mr. Smith on his cloud, I can't imagine is very happy with his lawyer's work, right? We want to do a little sample. We are going to go a little over the time tonight because we did start a little later to get people in, so bear with us just a few minutes. We have John and Mary's sample in our example here. John is 60, Mary's 58. They have a total of $1 million of assets in 2015, broken up in that way. Assume they each live till age 80. So John lives 20 years, Mary lives another 22 years. Under the traditional model, let's say they meet with the attorney and they do a sort of boilerplate, word processing thing. They pay a total of, say, $650 for the will. Of course, there's no funding and maintenance. If they meet with our process or meet with us, the $1 million estate would call for a $5,000 design and counseling fee based on the 0.5% fee structure. If they opt to do, in this case they did, a Medicaid trust, a joint Medicaid trust, we have another $1,500 fee. Total funding, let's say they had a lot of different stocks that had to be dealt with, was $750, a little higher than normal. And over 22 years, they would pay presumed about $8,000 in total maintenance fees over the course of 22 years, including some inflation built into that. So far, this looks like a better economic deal, I think we'd all agree. Their estate, when John dies in 2035, 20 years from now, has grown to just under $2.2 million based on 4% annual growth. Nothing crazy on that growth rate. John's portion, because he had more of the assets, is about $1.3 million. Mary dies 2 years later. Her estate is just under $950,000. So let's talk apples to apples now. Using a 2.5% probate fee, John's administration, because he owns separate assets, about $33,000. Mary, a couple years later, hers would be a probate fee of just about $23,700. And if an estate tax return was necessary for portability or otherwise, the separate fee is assumed at $5,000. Under our model, even assuming we're at the maximum cap, worst case scenario, a little over $13,000 to settle John's estate, Mary's just under $9,950. Comparing the two numbers, the total planning costs in the traditional model, $62,215. Worst case scenario under the Legacy Assurance Program, $38,000 and change. And which result is going to be better? I'd like to think we know which the answer is for that.